Hello, this is Jason Sansone, and welcome to the very first episode of The Legal Breakdown. I'm very happy to be able to bring to you this wonderful new program in conjunction with KTLV 1220 AM radio. So what is The Legal Breakdown? The goal of this show, every week, airing Wednesday from 5 to 5:30 p.m., it's a wonderful time slot. It's the drive home. Our goal is to inform you, the listener. We want to bring to you information from a legal aspect that can truly help either protect yourself, inform you, make the world around you maybe a little easier, maybe a little better. The reality, of course, is that there are so many things that you can be victimized, you can be taken advantage of, but you may not necessarily be able to hire an attorney or to get questions asked of an attorney. Those are the types of things that I hope we can provide completely free as part of this. Now, please, if you have questions, I want to make sure we stress this is a live show and you can call in at any time. 405-347-7238. We're going to say it several times over the program, especially because this is our first episode, but I want people to know they can call in with questions. We can take those questions. If you have questions that you'd like to be in-depth topics for entire episodes, you can email me. That email is on our website. You can find my website at www.sansone, S-A-N-S-O-N-E, Howell, Howell.com. So let's dig in for our first episode. Who am I? Why am I doing this? And then we can transition a little bit into today's program. My name is Jason Sansone. I'm a member at Sansone Howell Attorneys at Law. We are located in the Arvis Bank Tower right here in Del City. It's Suite 500, 4600 Southeast 29th Street, Suite 500. We handle a lot of the issues that face the average individual. We do divorce, we do criminal law, we do estate planning, we do bankruptcy. I believe that we've seen a lot of the areas, a lot of the ailments that affects the community, and our hope is that through this show, we can reduce some of those areas where you may not be able to afford an attorney, but you need an attorney. I originally graduated from the University of Oklahoma, where I received a bachelor's in business administration. While working full-time, I went to school at night full-time at Oklahoma City University, obtained my MBA, and then I have a law degree from Southern Methodist University in Dallas. I'm very happily married to my wonderful wife, Amanda, and I'm going to keep saying this several times over the couple of months. We are expecting a baby girl. Our daughter, Emery Joy Sansone, will be here May 25th. So I get the power of the mic to plug that as many times as I choose. And so very, very happy and blessed to be expecting a daughter in May. So now that we know a little bit about me, we know a little bit about the show, I want to segue into today's topics. We're going to touch on three things in our very first episode for this premiere. We're going to talk about some of the issues affected because of the government shutdown. I want to talk specifically about U.S. courts, bankruptcy and federal courts, as well as the Internal Revenue Service, your ability to file taxes or get tax refunds. How's this being affected by the government shutdown? Then we're going to do a quick legislative update, what's going on with the Oklahoma House and the Senate, and we're going to begin our multi-part series, which is going to span several weeks on bankruptcy, talk about some financial issues, how can you take care of yourself, or does bankruptcy make sense or not? So first thing up. Can you file a bankruptcy right now? Can you file federal litigation? Do you know? Well, unfortunately, the government has a funding problem, and as most people are well aware, we have been closed now for over a month. That we have not passed a budget or a continuing resolution, and that means that new money is not being appropriated to federal administration agencies. So originally, the United States court system thought they were going to have to they'd run out of money on January 18th. That was revised, and it was revised back to January the 25th. They've now revised it as of yesterday to February 1st. So the good news is that while we thought that we were going to run out of money earlier, we believe we're going to run out of money a little bit later. The bad news is that according to the official publication from the United States courts, they say, and I quote, "The judiciary continues to explore ways to conserve funds, but no further extensions beyond February 1 will be possible." That's next Friday. So next Friday, United States courts are going to run money. Now, just so that there's no confusion, we're not talking about Oklahoma state courts. That's clearly not a federal court. So Oklahoma City Municipal, Midwest City, Del City, not affected. Oklahoma County, not affected. Oklahoma Supreme Court, not affected. But the federal courts in our state, which would be the Western District of Oklahoma, the Northern District of Oklahoma, the Eastern District of Oklahoma, and all of their bankruptcy courts are going to run out of money next Friday. So what's going to happen? Unfortunately, those employees are going to be affected the same way as the other employees that have been furloughed throughout the country, and they're going to have to work without pay. They're going to go to 50% staff, the clerk's office and the chambers. The judges will still be working. The courts will still be open. So you still have the ability to file a case. You still have the ability to have a case filed against you. But there is going to be some complications. They're going to be short-staffed. Your attorneys are going to feel the effects of these things because motions may not be reviewed in the same amount of time. We may not get orders in the same amount of time. Some of the things that are not day-to-day critical, there's no question they're going to have to put to the back burner because you can't do everything you normally do when you only have half the staff that you used to have. So those are issues that are going to arise. How long that's going to be? Well, of course, nobody knows that. The issue is when can we get a budget passed? The other thing that's important to know about the courts, and this relates to our second point about the Internal Revenue Service, is that the civil division of the United States Attorney's Office has already been furloughed, and their job is to represent the federal government in all civil matters in the United States, including representing the IRS. So if there is a case that involves the IRS, whether you are attempting to dispute taxes, whether they're suing you over taxes, you've got a bankruptcy that involves taxes and the Internal Revenue Service, the government is a creditor, those cases are going to be stayed. They're going to be put on hold, push a big pause button, because unfortunately the government's interests can't be represented. They don't have anyone to speak on their behalf while that civil division is out on furlough. That's going to continue until we see a continuing resolution or a budget. So now let's talk a little bit about taxes. There was a period where the IRS was furloughed. They were closed. They've been brought back. They are working, not with pay, but they are currently working. So what does that mean? You can file your taxes just like you normally would, and we expect that you will receive a refund right now in a timely fashion. Next Monday, January the 28th, is when you can, for the first time, file returns. So electronic filing is going to become available. You can file that tax return, and then you can expect your refund in the normal course that you're used to in prior years. A couple dates that are important for everybody to be aware of. January 31st is the deadline for your employer to mail out W-2s. So at the end of this month in January, if you haven't gotten a W-2 yet, be looking for it in the mail. They must have mailed it by the end of the month. February 15th, halfway through the next month, is the deadline for 1099s to be mailed. So if you're an independent contractor, if you are contract labor, you're not a W-2 employee, you can be looking for those 1099s in February. March 15th, anybody who's self-employed, you've got a small business, maybe you've got a corporation, a partnership, an S corporation, you need to remember that your return is not due at the same time as your personal return. It's due earlier, and they will penalize you if you do not timely file it. That is March 15th. So part of the way through March, if you haven't filed for an extension or you filed the return, you need to be aware of that. Then April the 15th, most people are aware, halfway through April, that's the deadline to file what's known as a Form 1040. That is your personal tax return. You can file for an extension. That's going to take it out to October. I just want to remind people, common issue that I see or I encounter, file an extension simply makes it so you are not penalized for the non-filing of a return. It does not change when the tax itself was due and owing. So if you owe taxes and they are due mid-April, file an extension isn't going to help you out. It's going to just give you 6 months in which you still incurred interest and penalties for not paying the tax, but you don't get penalized for not filing your return. A much better option than waiting to deal with the issue and file an extension is to go ahead and file your taxes if you've got them prepared, if you're able to file them, and ask for a payment plan or some other solution so that you can begin chipping away at those taxes, because it will be less expensive in the long run than just waiting till October to deal with the issue. So we've touched on both what is going on with the United States courts as well as what's going on with the Internal Revenue Service as a result of this unfortunate shutdown. Let's segue now, talk a little bit about the Oklahoma House. Last week was the deadline to file bills for both the House and the Senate. Well, what's that mean, Jason? Why are we talking about this? So last year, we had an election, just like we do every 2 years, to elect all the representatives in the House, and then the representatives in the Senate served for 4 years. So half of the Senate was elected. We also, of course, elected a new governor. This was a gubernatorial year in 2018. Ultimately, the legislature is called what they are because their job is to pass legislation. If the people you vote for are not writing legislation, voting on legislation, then you got to ask what they're doing. They tell you when they campaign that they want to solve certain problems, whatever their platform issues were. The way they're going to do that, the way that we achieve things in government, is through those bills, through those laws. Whether it's repealing a law you don't like, whether it's tweaking a law you don't like, whether it's making a new law to help people, you've got to write the bills. So why are we talking about it? Throughout this show each week, like I said, we're going to mention it again. Every Wednesday, 5 to 5:30 p.m., we're going to be airing live. We're going to be taking your calls. We're going to answer questions. So every week, I want to check in. I want to see what's going on in the House so that we can look at what's being accomplished. Now, we just started a new session. We're just getting there. It's early on, but we're going to follow some of the big topics. We're going to follow how can that affect you. The goal of this show is not political. The goal of this show is informative. And so we're going to take these from an entirely legal standpoint and break down how could this affect your life. So we've got a hypothetical new piece of legislation about DUI. Here's what you need to know. Here's what this could do for insurance rates. Here's what this could do from a criminal standpoint. Be aware of it. We're just making up an example. But so right now, I've gone and I've looked at some of the legislation that has been proposed. The bad news is we've got nothing to talk about. That all of the representatives from this area in Middle and Oklahoma City have in large part submitted what are known as shell bills. And for the viewers who are watching this in our live stream online, I'm going to hold up a copy to see. For those that are listening on the radio, just assume I'm holding what is nearly a blank piece of paper. A shell bill is a placeholder. A shell bill is basically cheating. It's a loophole. Because you must submit bills by a deadline, you got to get something in, but this is, I actually haven't written and done the homework yet. So they submit a footnote that says, I'm going to come back later and I'm going to amend this bill. Personally, I don't like shell bills because from my point of view, you campaigned for something. You should have already know what you wanted to accomplish for the public. You should have already worked to write those laws and then make them visible and work on it. But unfortunately, they are common. They're used by all the political parties. They're used in both the House and the Senate. And they're used more prevalently in the House because Oklahoma, you are only allowed to submit 8 bills without permission from the Speaker of the House. That doesn't usually happen, and of course, only the majority party can expect to get that permission. So if you're in the minority party, you want to take advantage of your legislation, you want to make sure you submit those bills, but I'm going to personally say, I'm going to stress as the guy with the mic, you have to do the real work. Write the bills, do the research, know how it's going to affect people in the law. Shell bill isn't a real bill. It says, I hope to do something someday, but I haven't done it yet. So our legislative update isn't really an update at all because they haven't done their job over at the Capitol. Not a big shock, I know. We've got 15 minutes left on our show, and so I want to begin the first in what is going to be ultimately a multi-part segment where we talk about bankruptcy. Why would you ever have to consider bankruptcy? Unfortunately, it happens. There are issues that can affect your life, sometimes inside your control, sometimes outside your control. We see every situation you can imagine that can affect a household. I've had clients where they beat cancer, but they had $1 million in medical bills. I've seen clients where their child was born premature, was care flighted all over the state. They were dealing with nearly $500,000 in medical bills. These are not situations that anyone could expect to tackle financially in any reasonable period of time, and they're not situations that you could have avoided or of your own making. So there's a big stigma that is not true. There's a negative stereotype about bankruptcy debtors, and I'll say that a lot of the time it's not fair and it's not accurate to all the circumstances in their life. So what should you consider when we're looking at? First, in our program, we're going to discuss there are what are known as chapters. And you may have heard these terms like Chapter 7 or Chapter 13. Where do we get those terms from? Bankruptcy appears in the United States Code at Title 11. And so 11 United States Code, such and such are the different laws for what we call the Bankruptcy Code. Chapter 7 is the area that addresses liquidation. Chapter 13 is one of the available forms of reorganization. Those are the most common. Those are the ones people have heard about. There are others without question. You have 9, you have 11, you have 12, you got 15. Those are beyond the scope of our radio show, and they're really not necessary for our listeners to know about. You need to know about 7. So what is Chapter 7? With Chapter 7, you're going to prepare and you're going to file a bankruptcy. You're not going to have a payment plan. You're not going to be in that bankruptcy for an extended period of time over a period of years. Most likely, it's going to be over in under about 120 days. On the other hand, Chapter 13 is a form of reorganization. You're going to be in it a minimum of 36 months, that's 3 years, and a maximum of 60 months, that's 5 years. It doesn't mean you're going to repay all your debts. In fact, you might end up paying but pennies on the dollar to your unsecured creditors. It all depends on what are your debts, what's your income, what's your circumstances. Every case is specific, and we're going to dig into that over time as we do this multi-part series. But be aware that it is longer, it is more complicated. In all ways, it's more expensive, but it may have value. It depends a lot on what your circumstances are. So what are some of the differences between these two chapters of bankruptcy? What would lead a household to pick one versus the other? I want to pause for a moment. I want to remind everyone, as I'm going through this, you got questions, you're curious, you want to interrupt me, call in 405-347-7238. We're happy to take those calls. Time between filings. That is one of the first things that you, if you're filing on your own or counsel, should be looking at. If you've never had a prior bankruptcy, then it's not a problem. It's not going to affect your ability to file a future bankruptcy or current bankruptcy. But some people may have had a prior bankruptcy. It's 8 years between cases filed under Chapter 7 in which you've received a discharge. So if you filed a prior Chapter 7, we got to look at when that case was filed, and you cannot file another for 8 years. But let's say you need bankruptcy relief and it's been less than 8 years. Then you would need to look at Chapter 13. And that occurs. We've already discussed situations that can arise that are outside of people's control. Maybe you had a Chapter 7. 4 years later, you had a reoccurrence of the cancer that so tragically put you into financial straits previously. We have had this happen. We have had clients file Chapter 7s due to medical bills to only have to file another bankruptcy due to more medical bills. So those things occur. The second big difference between the chapters is what's known as the means test. And that is essentially looking at your financial eligibility to utilize Chapter 7. In a nutshell, if you are above the median income for a household of your size for your state, you probably will have to do a Chapter 13. Now, it's not that simple, but it's the easiest way to describe it, especially on air to our listeners. So you can look up the median income for whatever your household is. If you are married with 2 children, you're a household of 4. If you are single with no children, you're a household of 1. That information is available through the U.S. Department of Justice United States Trustee Program. They do a census data, and it's going to be updated every 6 months. They change it November 1 and May 1 of every year. The table goes all the way out to a household of 12, and then past that, you can add a flat number, no matter the size of the household. But if you are below the median, you should be able, if you pass all the other tests, to utilize Chapter 7 relief. If you are over that median, odds are you're going to be looking at Chapter 13. Okay? What else would lead one to want to pick one chapter versus another? The next thing that we're going to look at then is the sheer differences between the cases. Because Chapter 13 is a formal reorganization, it has a payment plan, and it will allow us to do things that we otherwise couldn't do in a Chapter 7 case. What are some of those things? Let's say that you have not been able to make a payment on your vehicle, your car, in a couple months. It's up for repossession. If you file a Chapter 7, it's going to temporarily protect you. You're going to receive what's called the automatic stay, and we'll talk more about that later. But once the case is filed, the creditor, your lender, can't take the vehicle. But eventually that protection goes away. You're going to lose that, and you're probably not going to be current on the vehicle. Odds are not good that you made 3 months of payments in a month or two to get caught up, and they could go right back to trying to repossess the vehicle. Same situation on a home mortgage. If you have not been able to pay your home mortgage in 6 months or a year and you're being foreclosed, maybe that foreclosure has been going on for quite a while and you are about to have a sheriff's sale. They are going to take this house from you. If you file a Chapter 7, you're going to get protections, but it's for a very short period of time. Once those protections go away, they could go back to foreclosing and they could still take the house. On the other hand, with a Chapter 13, what we would do is we would use that case to get you caught current. So whatever the arrearage is, how much you're behind, you're going to be able to use the maximum length plan, which is 60 months, 5 years, and you're going to get caught up on those payments while we make ongoing payments. We could be doing many things, such as not having to pay certain tax debts, paying off other tax debts you have to pay. Maybe you've got some medical bills or some credit cards. We can then deal with those. So Chapter 13 gets more complicated, but the third difference on our list of the differences between Chapter 7 and Chapter 13 is the nature of the case. That sometimes you could be eligible for Chapter 7, but you want to use Chapter 13 to accomplish your goal of saving a house or saving a car. The last big difference we're going to touch on today in this multi-part series is what is known as exempt property. Chapter 7 is called liquidation because anything that you cannot shield, anything you cannot protect, you're going to have to turn over to a trustee so they can take it and sell it and use that money to pay some of your bills, to pay your creditors. A business case, everything goes away. When a business files Chapter 7, they're going to liquidate everything. They're going to divvy the money up based on the bankruptcy law. They don't continue. If a business wants to continue and use bankruptcy, they're looking at a Chapter 7 reorganization with a reorganization plan, as opposed to what's called sometimes a liquidating plan. You can use Chapter 7 or Chapter 11, but still wind up affairs and go away. Like in a Chapter 7, it's just longer and more complicated. But talking about consumers, not businesses, of course we don't leave you with nothing. The law is not going to say, well, we're going to take everything and sell it. That's insane. So we have limits on what you do get to keep, because it's outside of our ideas of fairness to say you can have everything and anything you want, but also you don't have to pay your bills. So you can't have a Ferrari, a summer home, a motorcycle collection, and 4 boats and say, you know, I've got $1 million in debt. I want to keep all that stuff and I'm not going to pay my bills. Sadly, it doesn't work like that. If you want to keep the Ferrari, you might have to do a Chapter 13 or even a Chapter 11. If you're liquidating, if you do a Chapter 7, you only get to keep what the law shields. The bankruptcy code is federal, but the federal exemptions have what's known as an opt-out provision, and they allow states to use their own exemption list. And we're not going to go into all 50 states. We're only going to talk about Oklahoma. Oklahoma is an opt-out state. So in Oklahoma, we do not use the federal exemptions. They may appear in the United States Bankruptcy Code at 11 U.S.C., but we're not eligible in our courts to use them. You need to use state exemptions, which appear in the Oklahoma statutes. So some of the things that you can shield, your household goods and furnishings, you can shield professional health aids, hearing aids, if you have a wheelchair, if you have other things that are prescribed by a doctor. Your house, your clothing, wedding bands, up to a limit certain animals and livestock. This is a state with a very rural agricultural history. We're going to see that in our exemptions. We can protect firearms up to a certain dollar limit. But if you have something that is not protected, if you have something that is not shielded, then you would lose that. Well, in a Chapter 13, it's different. In a Chapter 13, you can keep whatever you want, but it affects the way we calculate the plan, because there's what's called the best efforts test, or best effort of creditors test. You must pay your unsecured creditors in a Chapter 13 plan at least as much as they would get in a Chapter 7. So you have a substantial amount of debt, you have good income, you also have some assets, and you don't want to lose those, such as mineral rights. We have had a client that had a decent bit of mineral rights. They inherited them. They didn't want to lose them, both for financial reasons and for personal emotional reasons. In that situation, we would file a Chapter 13 case. The other thing is that sometimes you're not even necessarily paying any more than you would have because of this. Your taxes that you must pay, and in another series we'll get into the complication of taxes, but if you have to pay certain taxes back as part of a Chapter 13, those are an unsecured creditor. Even though they're what's called a priority claim, they may have made it where you could keep property anyways, because the amount you would have paid in your 13 is the same as the value that you would have had to distribute in your Chapter 7. So this is where good counsel can be relevant, but also why we're going to inform the public on all these types of things as we go into it every week, Wednesday, 5 to 5:30, right now on the drive home. Make sure everybody's being safe out there. So we've touched on 4 big differences between Chapter 7 and Chapter 13. Just to rehash what those were, number 1, it's time between filings. Number 2 is the means test, meaning your financial eligibility to use Chapter 7. Third, we discussed the differences in the case. The fact you have a payment plan and you're reorganizing versus the fact you don't. And then lastly, we talked about this question of exempt property, or what can be shielded, what cannot. We are running low on time today, so I want to give a preview of what's now to come. In the last 3 minutes, we're going to discuss these things. In the future, we're going to discuss the timeline of a bankruptcy. What can you expect from when either you begin preparing one yourself or from the day you walk into an attorney's office? How long is it until my case is filed? Once my case is filed, what can I expect? What's the difference in those timelines between a Chapter 7 versus a Chapter 13? Those are all great questions. We're going to start to dig through all those issues. Coming up, though, we want to share with you some of the things that we've got on our calendar. In 2 weeks, we're going to have another expert on other than myself. We're going to talk about estate planning. We're going to talk about wills, trusts. In Oklahoma, we have a great system that allows us to avoid probate through the use of trusts. It can save your bequeaths, your beneficiaries, your family, a lot of time, a lot of money, a lot of heartbreak. Those are some things you should consider. Those are some things we're going to talk about. We're also going to have some experts on about oil and gas. What if you own mineral rights? How should you protect yourself? What should you do to be aware of those things? We have not gotten an exact date penciled in, but we want to have experts on to discuss some of these things that growing up are evolving with the medical marijuana laws, and we also want to talk about some of their interaction with other laws. There's been a lot of questions, there's a lot of misinformation about whether or not you can have a concealed carry license or a firearm license, as well as the right to, under state law, for the medical marijuana prescription card. We're going to go into some of those details. But I want your information. I want your input. What are issues you face every day? What are some things you've seen? We're going to talk about when landlords have the right to evict. We're going to talk about when they've got the right to foreclose. We're going to make sure you understand those and you can protect yourself. But email me, call in. Once again, it's 405-347-7238. This has been the premiere episode of The Legal Breakdown. Everyone be safe. Have a very blessed day. We'll see you next week.